Please be seated. We'll hear argument in 2293, City of San Antonio against Riojas.
I believe the gentleman stepped out just for a moment.
All right. We're ready for argument in 2293.
May it please the court, Mr. Moore will present argument for the petitioner. Petitioner has reserved 5 minutes.
May it please the court. It's actually hard to imagine a causal nexus more attenuated than the Court of Appeals found sufficient here to satisfy the operation or use standard for waiver under the Tort Claims Act. The causal nexus in this case is so attenuated that the Court of Appeals discounted the testimony of those actually involved in the accident, turned speculative conclusory statements by bystanders into circumstantial evidence, and even cited the city's Chapter 33 comparative responsibility pleading to fill a causal gap, the evidence left open. The court then compounded its error by imposing on officers the duty to engage in a needs-risk analysis in every routine decision they make, which is flatly contrary to this court's holding in Telthorster. The court should reverse and render for both reasons. I want to talk briefly about the facts in this case because it's what the Court of Appeals focused on. This is not a police pursuit case or an emergency response case. This is a routine case in which a police officer observed a traffic slowdown he believed merited activating his emergency lights to warn others of the situation. When he did so, Officer Tristan was in the far right exit lane. The dash cam video shows, which the court has, and if the court doesn't look at anything else, I'd ask the court to look at the video cam because I think it's conclusive. The video shows that before Officer Tristan engaged his emergency lights, the traffic in the far left and the middle lanes had already begun to slow. And we know this because when he engaged his lights, the video camera picks up 30 seconds before. So we know that the traffic was slowing in the far left and the middle lanes. That's in the record at 152. One car in the far left lane slowed, then another car behind it driven by Vela slowed, and then the motorcycle by the plaintiff, Riojas, slowed to avoid hitting Vela. He did not control his motorcycle. He couldn't stop quickly enough. He laid it down in the far left lane, and it skidded into Vela's vehicle. Neither Vela nor Riojas came into contact with Officer Tristan's cruiser. Indeed, before the accident, they did not see Officer Tristan, they did not see his car, and they did not know that he had activated his lights.
Is there a policy with the police department as to when a police officer sees this type of slowing down that they are to do blank?
There's not a mandatory policy. This is going to go, you're going to hear more about it in the discretionary section of what he believed in good faith, because they did raise a good faith immunity defense here. Whether he acted reasonably under the circumstances when he decided to engage his lights. What he testified in his affidavit is that he did not know when the traffic was slowing. He saw it. He saw a car Olvedo cut across and exit on the far right. He thought if he turned on or activated his lights, it would provide a warning behind him to the folks behind him to slow down.
My understanding of the record was that whenever the person in the white vehicle was exiting, that was after the slowdown had already started to occur, and that the reason that happened was because the person didn't want to get stuck in the traffic jam.
I agree with you. I think that's a fair assessment of this record. I think what the record is not clear about is the white vehicle that left the scene. But what is not disputed on this record is that before he activated his lights, traffic was slowing in the middle and the far left lanes. So the traffic had begun to slow before he activated his lights.
Are any facts disputed on this record? Any material, any facts material to the issues of nexus and good faith?
I do not think any facts are disputed on this record. I think it's whether they are sufficient to raise a fact issue, whether they actually constitute circumstantial evidence, and whether the Court of Appeals or this court could consider the allegations to be sufficient to create a fact issue on the causal nexus requirement.
So in that sense, this case is a little different than the one we just finished, because that one, the record does create an issue of fact, for example, as to whether the siren was on, although it's still up to us to decide whether, even if it was not on, that could be some evidence of recklessness or nexus or whatever, right? Here, it's a little different because it doesn't seem like there's really any fact that's disputed in the record.
I don't think, if there are any material facts that are disputed, I know that we will hear about them. I agree with you that I do not believe there are any material facts that are in dispute on this record. The Court of Appeals, in this case, like it did in Maspero, relied on the court's opinion in Ryder, and I think this is one reason Ryder is critical, because I think immunity waivers getting expanded under the Ryder decision in a way that the court did not intend on those limited facts and those limited pleadings. I won't rehash Ryder because I just talked about it in the last argument, but to find a fact issue here, the Court of Appeals discounted evidence, the testimony of the individuals involved in the accident, and relied instead on the speculative and conclusory statements of two bystanders who stated, and I think I have the quotes right, that Officer Tristan had no reason to activate his lights, and that his doing so scared that lady and caused a reaction that led to the accident, and that's in the record at 107. But under this court's holdings in Marathon Court versus Pitzner and Natural Gas versus Justice, which instruct that a finding can't be based on mere conjecture, guess, or speculation, the uncorroborated speculative conclusions of bystanders here is legally insufficient to create a fact issue on the issue of causation. And Justice Boyd, I think that's what you're...
So if Vela and Riojas had both testified in this record that, number one, they didn't think there was any reason to turn on the lights, and number two, the lights distracted each of them and they think therefore caused the accident, then you would agree that it does rise to the level of a fact issue on nexus?
I think if the participants in the accident had said, I was driving along and the officer flashed his lights in a way and it caused me to react and hit my brakes quickly, we would have a different discussion about immunity. But on the causal nexus, that would be some evidence that they said this was a but-for, this was actual cause, this was but-for cause of the injury. Both of them denied seeing him, his vehicle, or the lights, though, and I think that's critical.
But we didn't have that kind of testimony in Ryder, did we? From the distracted driver?
Well, I think the difference is in Ryder you had a case where the pleading was undisputed that the accident resulted from an officer's shining their high beam spotlight into oncoming traffic at night. And the court said in that circumstance, it's foreseeable of sort of the chaos that will ensue in the right lane. If you're driving toward a beaming light at night, that somebody can be night blind, that's foreseeable. I mean, it's kind of hard to imagine the consequences of the court holding that this case is like Ryder, that the minute a cruiser turns on their lights, it's foreseeable that somebody can react in a way that causes an accident and waives immunity.
To clarify Ryder somewhat, in standard negligence cases, attenuation is an issue that's part of the actual cause analysis. But here, under Ryder, we seem to be treating it as part of the proximate cause analysis, and that arises from, we said, it is something between actual and proximate cause, but then we conduct a proximate cause analysis. So what should the standard be in your view?
So I agree with you, because what the court did say in Ryder is it's more than actual. And so if someone shows proximate, they've satisfied the burden, but then the court leaves a void about what that should be. And I think that came from Chambers, where the court was asked to consider whether there was a fact issue on proximate cause, and I think that it developed because all the cases came forward from Chambers. It's picked up in Ryder. It's picked up in the court's jurisprudence. I think that, I think it was Justice Boyd and Maspero who asked, and I think that the causation analysis at some point has to focus post-Ryder on, it has to pick up other tort jurisprudence about superseding and intervening causes. And I think that's where the gap is in the causal analysis, because it's left void any analysis with regard to superseding or intervening causes, which is carried over into all the other courts' tort jurisprudence in negligence cases. Because the Court of Appeals...
If I could ask you about, we're talking about proximate cause and what Ryder says about it. The 101.021 says that the governmental unit's liable for personal injury proximately caused by the wrongful act or omission or the negligence of an employee if the injury arises from operation of a motor-driven vehicle. So it has to be proximately caused, and then if you clear that bar, you then have to show that it arises from, it seems like proximate cause is an initial bar the way this is set up, and then arises from is a second bar, and then of course that's perhaps confused by the notion that arises from is something less than proximate cause, but I wonder whether the way this is written, we ought to just go back to proximate cause as the standard.
I don't disagree with you, and I think that also got picked up from Chambers, because Travis County versus Mesquite, which was asked to decide proximate cause, it wasn't asked to decide operation or use. And so it was asked to consider proximate cause separately. And when you overlay operation or use, that's where the court's jurisprudence, Ryder, and the cases that are construing it, have construed what Ryder means differently and how expansive it can be. I think Justice Bland said in the City of Williams versus Baytown that you can consider, if you can consider someone like you could in Ryder a co-tortfeasor, is the operator of the vehicle doing something that's arguably negligent with regard to the use of the vehicle, I believe is how it got cast, and that makes sense in the context of Ryder. I want to talk very briefly about the bystander statements, because I think Texas jurisprudence is clear that you can't opine or guess about what somebody else thinks. It is no evidence for two bystanders to say he had no reason to use his siren, or that's what scared that lady when Vela and Riojas both testified that did not impact their decision-making at all. I think that allowing those two conclusory statements violates this court's equal inference rule in Lozano, because you can draw two equal inferences from those statements. It either did scare somebody or it did not scare somebody, but just them being bystanders, they weren't even eyewitnesses. They did not see the accident itself. They noticed that he turned his lights on. And so I think that it violates this court's equal inference rule in Lozano and Walmart versus Gonzalez, because at most, it's meager circumstantial evidence that won't give rise to a fact issue. Justice Chapa picked up on that and said there's a complete lack of evidence. Only got a couple of minutes left, so I'm actually going to hustle forward just a little bit, because I want to talk about something else that the Court of Appeals did that I think requires the court to correct it, because it's of such import to the jurisprudence of the state that the Court of Appeals here on the good faith exception of immunity imported the needs-risk analysis of Chambers, Wadewitz, Clark, and Manila into this case. Here, the city relied on Tristan's affidavit to demonstrate he acted in good faith when he said, and I quote, he thought it was the best course of action to take for the safety of others on I-37 South to turn on his lights. The Court of Appeals held that this affidavit was insufficient as a matter of law because Officer Tristan did not show he balanced, in quotes, balanced the need he perceived with the potential risk posed by his chosen course of action. But by imposing a needs-risk analysis in this routine traffic case, the Court of Appeals ignored binding precedent, specifically this court's holding in Teltorster. Teltorster specifically instructed that the particularized needs risk factors of Chambers, Wadewitz, and Clark were crafted in an attempt to tailor a test that would better weigh the risks that high-speed chases and responses pose to the general public. We just don't have those circumstances here. The court heard in Ms. Sparrow and in all the court's jurisprudence about the inherent risk to the general public of high-speed chases. That doesn't exist in a routine traffic stop situation. And the gravity of error is important because if the Court of Appeals holding in this regard is left untouched, it imposes on officers an unlimited duty to engage in a particularized needs risk analysis with every decision they make, whether to initiate a traffic stop, whether to turn on their lights, whether to engage their siren. Applying this new needs risk standard to a non-high-speed situation would virtually eliminate official immunity. And as this court explained in Teltorster, quote, in the routine work, police officers must be free to make split-second judgments based on their experience and training without fear of personal liability. And that's where the court went askew here. Officer Tristan's affidavit in this routine traffic stop is adequate for the good faith immunity exception as a matter of law. And the Court of Appeals erred when it overlay the needs risk analysis and said it was insufficient as a matter of law.
Any other questions? Thank you, Mr. Moore. We'll hear from the respondent.
May it please the court, Mr. Maloney will present argument for the respondents.
Good morning. I believe that we just have a fundamental disagreement about the facts in this case. You heard from the city saying that they did not believe that there is a disputed fact situation in this case, where I would respectfully disagree that the very basis of the court's opinion, fourth court's opinion, was that there was a fact issue raised. Specifically, there is video evidence which has been transcribed and video evidence that the court has available to view, which contradicts directly the city's position in this case. The city has stated that this is mere speculation on the part of the two eyewitnesses who were present at the scene. And the basis on their speculation was that, well, they didn't actually see the accident itself. I would respectfully disagree. That's not what they said. The transcript is clear and the video is available for viewing when the two individuals, who, by the way, stopped, helped Mr. Riojas after the accident, and actually waited for the police officer so he could confront the police officer, two independent witnesses who both independently said, it was your fault. We saw the accident. The actual statement they said to the officer at the scene, it was your fault. Question, the witness stated, I saw what happened. Question, it was your fault. Let me explain what happened. Witness 2, we've got witnesses. The two witnesses were in the proximity, they were there, they stated they actually saw what happened and that the activation of the lights, in their opinion, was the cause of the accident. That cannot be speculation when the proximity and the timing is two eyewitnesses at the scene. If we are now at a situation to where it is speculation, where two uninterested witnesses approach a police officer and quite frankly have the audacity to tell him you are at fault in an accident, I do not believe that can ever rise to the level of speculation.
No, but isn't the key what was in these people's minds as they made the decision to abruptly stop or to do whatever it is that they were doing that contributed to the accident? And isn't that by its very nature speculative?
In terms of the actions of the individuals who created the incident by braking, well, I think that motivation, I think, is secondary to the action of what Officer Tristan did. The braking, his reaction was to activate lights, in his opinion, to notify people behind him that there may be an incident in front of him. Now, the motivation of someone braking, it could have been an obstacle in a road, it could have been another accident. I don't believe that is relevant to the issue of the actions of Officer Tristan.
Let me pick on that a little bit.
Sure.
It's undisputed that the officer turned on his lights and that very quickly after he turned on his lights, Vela slowed down abruptly and then Riojas lost control and slid into Vela. All that's factually undisputed, is that correct?
Actually, Justice, no, that's, the city is actually contesting that. What they're saying is the activation of the lights was actually predicated upon the actions of the two cars in the video cutting across the intersection, cutting across the highway. And in fact,
Well, so they're
sorry.
saying cars in the far left and center lane were slowing down abruptly even before the officer turned on.
there was a
his lights.
slowdown.
But everybody does agree that that he did turn on his lights and that pretty quickly, if not immediately after he turned on his lights, Vela slowed down more and Riojas slid under Vela.
The facts that, yes, in fact,
Okay.
that is the basis of the lawsuit, quite frankly.
And so what you're saying is there's a genuine dispute over whether the turning on of the lights caused Vela to slow down abruptly and Riojas to slide under her.
Absolutely.
Okay, and so you have two eyewitnesses who say they think that the turning on of the lights caused the abrupt slowing down by Vela.
That's correct.
What does Vela say about that?
Vela says she did not see the activation of the lights.
Right, and so you say now, but it doesn't matter why she slowed down. And but doesn't it matter? Because isn't that the key to your causation argument, is that Vela was a she, right? Am I
Yes,
getting
that's
that?
right.
That she slowed down abruptly because the lights caused her to do that? That's your whole case.
Well, no, actually, respectfully, what the whole case, in our opinion, is that the slowdown, regardless of why the slowdown occurred originally, because you have two events. In effect, you have the original slowdown, and then you have the activation of the lights after the
Right.
slowdown. So the question being, if there was she's reacting to the slowdown, what predicated the slowdown? Was the slowdown generated because of the action of the police officer, which the eyewitnesses are saying, or was it predicated upon the fact that some other matter happened in the road in front? What I'm simply suggesting to the court is that there is a fact issue to that. What is the cause of the actual slowdown? And I don't,
Talking about the slowdown before the lights came on or the slowdown after the lights came on?
actually before and after. Because you have to have a situation to where, what caused Mr. Riojas to lay his motorcycle down? I don't think there's any dispute that vehicles stopped in front. I think those are indisputed facts. The question is, what caused that slowdown? Is the slowdown predicated upon the eyewitness testimony, which says, I think it was, hey, bro, you activated your lights, you caused this accident? Or is it because an event that occurred prior to that, because someone, either there was some debris in the road or whatever the reason may be? But when you have actual witnesses saying, officer, your actions caused this accident, we were there, we saw it. And the officer saying, no, it was some other vehicle that cut across that caused the accident. Inherently, you have a fact question at that point.
Is it a good rule as a matter of policy to impose liability on police officers for activating their lights because drivers might be scared by that?
I think
Isn't the whole point of the lights to warn?
Justice, I think that, again, every single fact situation is going to be dependent on what is the opportunity for the activation of the lights at that point. I think as a public policy measure, of course, I think it makes common sense that they may have to activate their lights in order to warn people because of a potential hazard. Question, I think, in this case was that activation warranted predicated upon the action facing the officer at that time?
Well, a slowdown on a freeway, I mean, people back behind are driving 70 miles an hour. They may not know that there's slow traffic. And it just seems to me if this situation had gone such that he didn't turn his lights on and then somebody plows into the back of slowed traffic that they couldn't see, we might be here having the same conversation about, well, he should have turned his lights on. Kind of like in the last case, should have used the siren, and this accident happened because you didn't turn your lights on. I mean, the same situation could happen where you can make the claim that his turning on or not turning on of the lights is what caused an accident on a high-speed freeway like this.
I think the fact that we're even having this argument substantiates the idea that there is a fact question here to be determined. I think we can talk about the public policy, and I
I'm
agree
sort of
with you.
moving over to immunity now.
Oh, I fully understand. But in terms of just the basic, is there a fact issue here? We're having the debate about what the facts are in the case right here. And I think that rises to that level.
What, do you agree that there's a disabled vehicle or some vehicle on the other side of the highway and there's a car behind it with lights on? And is that car potentially complicit in the cause of this accident?
No, Justice, I don't believe so. I mean, I think really what this boils down to is Officer Tristan decided at that point in time, he activated his lights when there was no emergency in order to do so. Now, the activation of those lights, according to the eyewitness testimony, was, in their opinion, the reason this accident occurred.
And so I'm sitting here thinking about how you answered that earlier.
Well, I did my best.
So the witnesses say the activation of the lights caused the accident, but Vela says it didn't cause her to slow down abruptly. So what you're saying is the activation of lights might have caused people in front of her to slow down abruptly that then caused her to?
That could very well be the case.
Now, that would have to be in order to create the causation that you're wanting us to.
I fully agree.
Okay.
That is exactly what we need to determine on a factual basis. And I'm anxious for the official immunity, because I know that's coming. So the official immunity.
Well, it seems like the rule you're asking for on official immunity is to tell officers, don't turn your lights on to warn people of slow traffic ahead. And I have difficulty imagining that's a good rule, but address the circumstance of if that were the rule, wouldn't that be just as likely to cause an accident? With people not being warned of slow traffic ahead might plow into it. The officer's in a tough spot there if both courses of action might cause an accident on a busy highway.
I agree that on this issue that it has to be looked at on a fact-by-fact basis. Because obviously the precedent in the case is in pursuit cases, a need risk analysis is a predicate in order for the qualified immunity to apply. There has to be some sort of need risk. The question, and the expansion of that I would look at, I think Bonilla also may address this, was the issue of this, and that is it the action taken that may put the public at risk is the issue. The question is, certainly in high-speed pursuit cases, I think it's axiomatic that you're going to have to balance that test. The question is there an expansion to that of a situation to where the action of the officer can put the public at risk? Albeit, is that thin? Sure. I'm not going to sit here and try to deny that. But I think it is an expansion that is something to be looked at and maybe warranted. And that is, you put, as you were discussing, a 70-mile-an-hour highway, people coming over a hill, putting the public at risk. The question is it that much of a burden to ask the officer, well, look, you know that road, you pull off to the side, you put those lights on, there's not one person on that highway who's not going to hit their brakes and slow down. And was that a consideration? And the affidavit is completely lacking in any sort of analysis. And where the fourth court was an aggressive expansion, I'm not going to sit here and say no, it was. However, is it predicated upon the idea that the action taken by that officer needs to be taken in context of what he was doing at the time, and that is a highway, high traffic, high speed, and he decides to make a decision that could put the public in peril. I don't think it's too much of a burden to say, give us an analysis of why you made that decision, which is totally lacking in this case.
Didn't his affidavit say, in order to warn other motorists of the traffic slowdown ahead, I determined that the best course of action was to slow down and turn on my emergency overhead lights?
I believe the affidavit does say that.
And so why isn't that enough to justify his course of action under the circumstances presented? Which is, I think, Bonilla, whether you articulate the factors or not, what we're really talking about is looking at all of the circumstances that are available to the officer and asking, could a reasonable police officer have been justified in taking the course of in good faith in taking the course of action that he or she did?
I think that's a fair analysis. However, again, and to belabor the point, I think you need to take into consideration that event that is occurring, if I may, on a slowdown on I-35, at 70 mile an hour traffic, coming over a hill, and you're sitting there with a police officer saying, I am going to immediately activate lights. He's saying, well, in my decision, this is actually going to help warn people behind coming over a hill at 70 miles an hour. Well, obviously it did not, because we have this accident today. Some people were not warned of it, and an accident resulted. Fortunately, the injuries were not nearly as serious as obviously the case you heard before. But again, I think it's a legitimate inquiry as to, should he be required to discuss alternatives? Our position is that they should. The other issue, I think, is this attenuation. And it's interesting, the argument about attenuation, because the issue about attenuation, and again, and I'm going to digress for 1 second because I just want to give a shout out, because I've been looking at the PHI decision, and it had a paragraph in there that was the most inspiring common sense argument about the use of words, about use and operation, and how we strangle words sometimes in order to just get away from their common meaning. And attenuation, where I'm going with that argument, is this: is that attenuation should simply be two issues, the action and the timing and the proximity. I think the first analysis should be, what's the timing and the proximity? Was the actual vehicle, the police vehicle, in the area at the time? And at the time of the accident, was he taking an action at that point? I think attenuation needs to start. Then you need the analysis of the action taken. Was that so attenuated to the ultimate event that occurred, the accident itself? And in this case, we have the following. We have almost an immediate reaction within seconds, which is demonstrated by video, of the activation and the accident ensuing almost immediately afterwards, within, I think, 10 to 15 seconds. The issue being that those two issues, timing and proximity, are met. The issue, which I believe is a fact question to be decided, is whether or not the attenuating circumstances are dictated by the action taken by that police officer. And that is, again, I think, best left to the fact finder to determine the credibility and weight of the evidence given by the two eyewitnesses.
If we were to decide that Teltorster is the correct test on going back to the good faith issue, and that a needs risk balancing is not required, what would your argument be in that case?
I think in that case, I think it is obviously very clear to Teltorster that you're going to need a needs balancing test. I don't think it's obviously going to be needed in every single instance of every single report, which is what the city is basically saying that the fourth court is expanding it into, that every single incident is going to require that. I think it is the action taken by that officer which could expose the public to a risk greater than that of a typical routine stop. I think that is the fundamental difference. I think there needs to be an analysis, a deeper analysis into the actual event itself. I agree that in high-speed pursuit, absolutely, that there needs to be the needs risk test. Do we then carry that over into other, I can't call them routine, because if someone gets badly hurt by the action taken by the officer because of the risk he took in the decision he made, I think that's a different matter. Juneman, I think, was the case back in 2002, I believe, in the Houston court, where they did a similar analysis in that regard. And they determined that because there was no alternatives discovered, there was no alternatives that were discussed, as such that the affidavit was defective and whatnot. Bonilla obviously subsequently came after that, and the other cases did. But I think it was a fair analysis. Is it too much of a burden to suggest that alternative methods should be discussed in the risk need analysis other than in pursuit cases? I think it's predicated upon the action of the officer that may put the public at risk. The city, with regards to the issues that the city has brought up regarding the speculation, and I think the court addressed the issue of speculation in this case. It was actually their primary argument in the fourth court, and that was simply that these witness statements must be speculative because they did not witness the actual accident itself. Again, I just believe that misrepresents the record. I think it misrepresents what's on the video. I believe that the court can make that determination for themselves. These witnesses, in fact, state very emphatically, they saw it. They were there. They approached the officer. They gave a statement. So that cannot, by its very nature, rise to the level of speculation. If, on the other hand, they drove up on the scene, they saw Mr. Riojas on the ground, they saw the police officer's lights on, and they went, well, you must have caused it because your lights are on and he's on the ground, pure speculation. This case is different with regards to that factual scenario. I believe that's all I have. Thank you.
Any other questions? Thank you, Mr. Maloney.
Thank you.
And Mr. Moore, you have 5 minutes.
Thank you. I'm going to start at the end and go backwards, I think, the most recent. I'm going to start with a couple of things, and one that is about whether it was speculative. We have cited a case in our briefing, Vanderlyn versus Kahn, that says it's not proper to have testimony about what another person is thinking. And so, for example, if I had stuttered when Justice Busby asked me about what tort test we imposed post-Ryder, then it would still be speculative if Justice Bland said that his question scared me, and she knows it because I stuttered. She would not be able to talk about my state of mind, and that's what happened here. And Justice Blacklock, I think that's why we don't have a disputed material fact. And you've keyed in on it, and that is they've allowed two bystander statements to talk about what somebody else was thinking. Neither Vela nor Riojas said that was the reason. And you went a step further and said perhaps the car in front of them slowed down.
Because of the lights.
Because of light. That is contrary, I believe, to the dash cam, but at most, I think Justice Chapa points out, it's just a step too far. There's no evidence to support the gap that an unidentified driver who left the scene actually initiated braking because of the lights. That actually takes me into a little different fact I want to focus on now about this new needs risk analysis. If we expand it, as they've asked the court to do, maybe not to Teltorster's level, but to expand it anyway, I just want to ask what happens in this circumstance. They're asking the court to expand it here because he and his in-the-moment split-second decision-making, like Teltorster said, decided for the safety of others it would be beneficial to activate his lights. What if he had witnessed Ms. Oviedo cutting across traffic and had activated his lights to initiate a traffic stop? The reason for the activation of the lights doesn't matter. The impact would be the same. So how do we get into that space where we're going to impose liability on officers and require them to assess in real time in the moment in a routine stop, is this an appropriate use for something that I use all the time? I activate a siren or my lights. And I think it's unreasonable for the court to expand its jurisprudence past Teltorster, Chambers, Wadowitz. All of those cases talk about the court struggling to come up with some kind of balance because we know high-speed pursuit chases can cause public injury. And so the particularized need risk analysis came from that recognition that we have to have some sort of balancing test that before somebody does what they did in the Chambers case, and they were chasing a cyclist, I believe, up to 100 miles an hour, or in the Teague case where 6 or 8 officers were engaged. One of the cases cited where they actually bumped the vehicle. There is particularized need risk. Sometimes the court has recognized that the officers are justified in taking even those extreme actions, but this is just not one of those circumstances, and it would be unreasonable to impose on everyday officers and everyday routine decision-making to require them to do something more than Officer Tristan did here when he said, in my best judgment in the moment, I thought the best thing to do was to activate my lights to warn the other folks behind me of the traffic slowdown. Interesting fact, Juniman came out by Justice Taft. The court relied on it to expand Teltorster's holding. 6 days after this court's opinion in Teltorster, I think inside baseball from the 14th Court of Appeals and the first, I don't think Justice Taft had the benefit of Teltorster when he imposed that standard. No case in 21 years has imposed particularized needs risk analysis until this court did it in this case. So we would ask the court to reject the expansion of Teltorster's standard here. The only other thing I would say is that all of the evidence that the Court of Appeals relied on to do what I think was improperly create a fact issue is no evidence at all under this court's prior holdings of Walmart and Lozano and Ford Motor Company versus Ridgeway. It's not anything that rises to more than a scintilla. It's meager circumstantial evidence, and it's insufficient on this record.
Any other questions? Thank you, Mr. Moore. The case is submitted, and the court will take another brief recess.
All rise.